Have you ever wondered what happens to a person's assets after they pass away? Who makes decisions about their estate and how this process affects the loved ones left behind? Stick around as we delve into the often misunderstood process known as probate, shedding light on what occurs when someone dies and how it impacts their family's future. Hi, I'm Cindy Kang, founder of CMK Law Group. I am an estate planning and business attorney in California, and I help families with their estate planning needs. I also support entrepreneurs with their business formations and business law requirements. In this episode, we'll delve into what probate is, why it's a hassle to deal with, the typical costs and duration of probate in California, and most importantly, how to avoid it. In California, understanding the probate process is crucial as it can be lengthy, costly, and burdensome. We'll also debunk common misconceptions about wills and probate and explain why establishing a revocable living trust, or RLT, is often the preferred solution. So let's dive in. What is probate? Probate is a court-supervised process that occurs after an individual passes away, regardless of whether or not they have a will. During probate, the court oversees the validation of the deceased person's will, if one exists, identifies and assesses their assets, settles debts and taxes, and ultimately distributes the remaining property to designated beneficiaries. It's important to know that dying without a will, or dying intestate, and dying with a will both guarantee probate. Why probate is a pain. Probate in California can be a cumbersome and costly process. The typical cost of probate in terms of a percentage of the value of the estate can range from 4 to 7%, or even more, depending on various factors such as the complexity of the estate and attorney's fees. In fact, there is a complicated formula that California probate fees are based on, with the first $100,000 of assets having a fee of 4%, the next $100,000 3%, the next $800,000 2%, the next $9 million at 1%, and the next $15 million at 0.5%. That's hard to compute, but in practical terms, in the form of an example, if you have an estate where the person dies with $1 million in assets, that estate would pay just under $50,000 in probate fees. For someone who dies with a $5 million asset, they would pay just about $125,000 in probate fees here in California. That $5 million estate sounds like a lot of money, and it is. And many people might think, well, that doesn't apply to me. I don't have $5 million in the bank. However, many people don't realize that just adding up their real estate properties and their life insurance proceeds, which can be counted in your probate estate if at the time of your death, the beneficiaries to your life insurance are minor children, then all of those assets are counted, and you could quickly see how you could get to a pretty high number in California. Moreover, the duration of probate proceedings can vary widely, but it's commonly taking about 1.5 to 2 years to complete a probate proceeding in California. That means that during this long process, your children or other loved ones that you leave behind will not have access to your funds during that time, and it's already difficult as it is. But to not have access to any of your financial assets on top of everything is a pretty terrible thing. So now, debunking some probate myths. One common misconception is that having a will can somehow avoid probate. But in reality, actually, having a will pretty much guarantees that you will go through probate, because it's the probate court that will have to validate and carry out. Another myth is that dying without a will means that your estate will automatically go to the state. While intestacy laws govern asset distribution in the absence of a will, probate's still required to settle the estate. So how do we avoid probate? Fortunately, there are effective ways to bypass the probate process and minimize its impact on your assets and your loved ones. One solution is to establish a revocable living trust, or RLT. Unlike a will, assets held in a properly funded RLT can avoid probate entirely, allowing for faster and more private distribution of your assets to your beneficiaries. While an RLT is often the preferred option for estate planning in California, there are scenarios where having a will might make sense. For estates valued at $184,500 or less, which is the current exemption amount in California in 2024, a simplified or fast-track probate process may be available, making a will a viable choice for those with smaller estates or specific circumstances. However, if you own a home or condo anywhere in California, the chances are quite high that your estate would exceed that $184,500 amount, and that you should probably get a revocable living trust instead. There you have it. We've discussed what probate is and why most people want to avoid it. Remember, understanding probate and its implications in California is essential for effective estate planning. By taking proactive steps to avoid probate, such as establishing a revocable living trust, individuals can ensure a smoother and more efficient distribution of assets while minimizing costs and stress for their loved ones. Whether you're considering a will or an RLT, it's important to consult with an experienced estate planning attorney to tailor a plan that meets your specific needs and circumstances. If you're located in California, consider reaching out to us at the link in the description box below. And if you found this video helpful, please be sure to subscribe to our channel for more tips about estate planning and small business law, and share it with your friends and family so they can secure their family's future as well. Thank you for watching.